Thank you and welcome to everyone for joining us today. This is the American Bar Association section Civil Rights and Social Justice, and this is our fourth annual State of Voting Rights panel. I'm joined by many experts here that can help navigate these rough waters. But first, there are a few folks that I do want to thank for helping make today happen. First, Paula and Allie with the American Bar Association. Thank you for all of your organization and your assistance. The section in general, thank you for your help. Wendy Mariner is our leader, so thank you for all of your help and support. The Committee on Civil Rights and Equal Opportunity, Janelle George, Jamie Hawk, and Kathleen Yahara, thank you for your help today too. And final thank you to Steptoe, my employer, so I have to thank them. But thank you for your hospitality here and letting us take over one of the conference rooms. I don't need to tell you that every day it appears that there's a new attack on voting rights in this country. And it's not just on the federal level, but on the states and in our cities as well. But the efforts to curtail voting, nothing new. This is a battle that we have fought for decades. Unfortunately, we will need to continue to fight. So what do we need to do to protect the franchise and to resist voter suppression efforts across the country? As I mentioned, we are lucky to be joined by these amazing advocates who will help us understand not just what's happened in the past, but also what's going on right now and what we can do to take action moving forward. So without further ado, I will start with Professor Daniels. Professor Gilda Daniels is an associate professor at University of Baltimore School of Law and litigation director at the Advancement Project. Previously, she served as deputy chief in the Department of Justice Civil Rights Division voting section under both the Clinton and Bush administrations. Prior to her extensive voting rights work, Professor Daniels was an attorney at the Southern Center for Human Rights, where she worked on prison condition litigation and represented inmates on death row. Her new book, Uncounted, The Crisis of Voter Suppression in the United States, is due out in January. Next to Professor Daniels, in the middle, is a veteran of this panel, so we thank him for coming back. Orion Danjuma is a staff attorney with the ACLU's Racial Justice Program. Most recently, he was involved in litigation in Florida regarding Amendment 4, and prior to that, against Kansas Secretary of State Kobach over that state's proof of citizenship requirements when registering to vote. As a result of his efforts in Kansas, the federal district court struck down the law, finding that it violated the NVRA and the Constitution. Previously, he was a Skadden Fellow with the ACLU Immigrant Rights Project. He received his JD from Stanford Law School, where he's a public interest fellow, co-president of the Black Law Students Association, and a symposium editor of the Stanford Law Review. And sitting closest to me is Mr. John Powers, and we thank John for serving on the panel today. John is a voting rights attorney at the Lawyers Committee for Civil Rights Under Law, where he joined in 2015. John's work at the Lawyers Committee focuses on litigation and election protection efforts directed at voter purges and other barriers to the ballot box, as well as discriminatory redistricting plans. Prior to joining the Lawyers Committee, John worked for more than 8 years at the Department of Justice, where he was part of litigation teams challenging the Texas voter ID and North Carolina omnibus election laws in the federal district court. So thank you to all of our panelists. The way it's going to work is each of the panelists will have about 15-20 minutes to speak. Then we'll open it up to questions, and we are live streaming on Twitter, so we'll be able to fully take advantage of the 21st century and get some questions over Twitter as well. So without further ado, I will turn it over to John and take it away from here. Thanks, John.
Thanks, Jason, Allie, and everyone for inviting me, and thank you to everyone for being here today. It's a real pleasure. I'm going to start by discussing some of the past and how we got here, some of the current challenges that we at the Lawyers Committee are working on today, and end with a hopeful note and a plug for the future. starting with the past, I can't help but think about the loss of Section 5 of the Voting Rights Act as a meaningful entity in the wake of the Supreme Court decision in Shelby County versus Holder. I can say when I was at DOJ, I reviewed thousands of voting changes that were submitted under Section 5, and there's no doubt that there's a connection between the loss of Section 5 and the fact that the Lawyers Committee, the ACLU, NAACP, LDF, and other organizations are all filing record numbers of voting rights lawsuits. We're truly playing whack-a-mole. We're in fighting tooth and nail at not only the state level, but the county and local level, where one new act of voting suppression pops up. We fight it. We've won some, we've lost some, and then new challenges pop up after that. In terms of some of the challenges that we're facing right now, I'm going to talk about 4 different buckets, areas in which the Lawyers Committee is involved and engaged in litigation. One of them is voting rights purges, registration lists shortly in advance of elections. Another is polling place changes to that are often discriminatory or made on the eve of election without informing voters. Another major challenge is increasingly old, defective voting machines that aren't appropriately recording votes and don't leave a paper trail. The last is challenges for students registering and trying to vote at campuses across the country. With respect to voter purges, this is a perennial problem. The National Voter Registration Act is designed in large part to prevent these kinds of purges. There's a strong tool there, yet this is an example where at the county and local level, it's hard to keep track when, in Georgia, where we're very involved, there's 159 boards of elections. It's not like the Secretary of State is, although I should amend that, the Secretary of State is purging roughly 300,000 voters in Georgia in the coming month, and that's a big and separate problem in and of itself. But what we're seeing at the local level are really invidious purges that kind of sneak under the radar. For example, in one county in Georgia, county election officials are talking to municipal officials and are saying, hey, can you tell us who's disconnected their water bill? Because we're going to challenge those voters, and if they don't respond to a letter that's mailed to them, purge them in the next month. That's illegal, violates the NVRA, which requires that these voters, A, be sent a confirmation notice with a returnable postcard, and then even if they don't respond to that notice, they should have 2 federal election cycles before they're actually removed from the rolls, but instead the boards of elections are just kicking them off unceremoniously. Another egregious example in DeKalb County, Georgia, right outside the Capital, you have these same kinds of purges where they're asking municipalities for lists of voters they can just take off, and they're saying, for example, that voters, there's this one detail that I just can't get past. Every time voters register at a rehab center, it's the Peer and Wellness Center, these are people who may have had problems with homelessness, they're going through a difficult stage in life, and they go to this center to live for a few days or a few weeks. Often part of the process of helping them get back on their feet, helping them feel engaged, the director of the facility helps these individuals register to vote. Every time people at this register to vote at this facility, the election officials kick them off. And of course, it's not a requirement to vote that people live at a specific location. That's, obviously anyone, if you're a citizen and you meet the other minimal requirements, can vote, even if you're homeless or don't have temporary housing. So these challenges happen both at extremely high levels, affecting hundreds of thousands of people, and at the local level. And all these changes make the most vulnerable voters, people who are most susceptible to these kinds of changes, not wanting to vote, not wanting to make that step of trying to participate in future elections. Another issue that we're really on the lookout for in the upcoming election cycle are last-second polling place changes. Some of you may remember in 2018, Randolph County, a majority black county in rural Georgia, the majority white board of elections there moved right before the historic election involving Stacey Abrams to eliminate nearly all of the county's polling places, including those in minority communities. Just recently, before the last municipal election, the city of Jonesboro, which also has a large, substantial minority population and an unfortunate history of criminal justice problems and police misconduct, moved their polling place right before Election Day to the police station. They said that the voters would feel safest at the police station. And most remarkably, they had a camera in the right above the voting booth. I wish I had a picture of it, suspended a couple of feet above, and it creates obvious concerns that voters might not feel comfortable coming to the police station at all. For example, the city had enacted saggy pants ordinances and other measures that caused real concerns that there might be some kind of incident when people appear to vote, and also might not feel secure that they'd be able to cast a vote and have a right to a secret ballot. Another issue, and this kind of gets more to recent litigation that we've been engaged in, is the voting machine issue, where you have a number of states across the country who bought voting machines after the Help America Vote Act was passed in 2002, and many of these machines were really, frankly, problematic for them from the very start. And to me, it's shocking that we're still here in 2019 and states are still using them. Many states still use, or too many states still use voting machines that have absolutely no paper trail. They're electronic devices where you type in who you want, and there's no paper comes out at the end of it, and that creates real vulnerabilities. The Lawyers Committee joined organizations in a lawsuit in Georgia. It's called Crowing versus Raffensperger, where we got a preliminary injunction. I think the first time that I'm aware of that a federal court has enjoined a state's voting system for use in future elections. And for example, at last year's preliminary injunction hearing, there was a computer scientist who came into court with one of Georgia's voting machines, and in a short amount of time was able, it was like, I forget if it was 10 minutes or 20 minutes, was able to reprogram it so it could flip votes without leaving any trail whatsoever. And he also demonstrated that he could make the voting machine play Tetris. These machines are absolutely not secure whatsoever, and frankly, the deeper I've gotten into the case, the more concerned I get about the integrity of elections in Georgia, Mississippi, Texas, Ohio, and other states, Pennsylvania. Some of those states are transitioning away from using these paperless devices, but some of them, I know at least many counties in Texas and in Mississippi, there are plans to continue using these absolutely paperless voting machines in the future. And I should add that even for the so-called next generation of voting machines, which I caution, for example, Dominion's latest voting machine runs on Windows 7. So I question how next generation it really is. But Georgia's moving to this machine where again, it's electronic. You type it in, and you get a printout, and on the screen is a barcode, and then underneath the barcode is the actual text of who you voted for. And what's interesting to me about it is, you scan in the paper. The scanner reads the barcode, not the text. And obviously there's no way to confirm that what's on the barcode actually matches what's in the text. And what's even more interesting is in a recount, they're supposed to count the text and not the barcode. So you could have a situation where if in the event of a recount, you could see wildly different numbers if the numbers don't match up. So it's a major area of concern that I encourage anyone who's kind of looking at getting engaged from a pro bono perspective to think about and look at. Another perennial issue that came up this year, and I'm sure will come up in 2020 as well, relates to registering and voting by students at colleges and universities. In Virginia, which at least coming into this election wasn't at the top of my list of jurisdictions where I thought we were going to have issues. There were big issues, and in Virginia there are problems with students who register and live on campus, and a question arose where a registrar in Fairfax County said, and we were talking about students at George Mason University. 26,000 students at George Mason live on campus. He said, I'm going to reject, and did reject, every voter registration application that comes in from a student that doesn't provide their dorm name and room number on their voter registration application, even though that information isn't asked for on the voter registration form. So the result was, and I don't know why he timed it like this, the day after the registration deadline, October 16th, he sends out hundreds of rejection notices to students who had applied to register to vote, usually through voter registration drives throughout September and the beginning of October. That, obviously being after the registration deadline, caused us to have significant concerns. We dug a little deeper, and it turned out that the Virginia State Board was taking a very equivocal position on this issue and not working to clear it up. So the problem seemed to be in some colleges and universities in Virginia, you don't need to provide your dorm name, but in others you do. Big concern for us, because George Mason is one of the most diverse colleges in Virginia, and there are a lot of students of color who are trying to participate in elections for the first time, getting this notice and wondering what's going on. So we eventually did bring litigation with partners from Kirkland and Ellis, and I'm happy to report that we were able to achieve a consent order on the Friday before the election that allowed the affected students to cast a provisional ballot that should be counted. The Fairfax Board of Elections is actually starting to count their provisional ballots today, and we're staying on top of them to make sure that they do the right thing, and we were able to engage partners on the ground and hopefully make sure that these students don't have a negative experience that dissuades them from voting in future elections. But the registrar is still not said definitively that he's going to accept these registrations in the future. So I definitely think going into 2020, we need to keep that group of voters in mind. I could talk all day, but maybe I'll stop right there and turn it over.
Thank you. That's an incredible overview, John, of all of the issues that are facing advocates in this field. My name is Orion Danjuma. I'm a staff attorney with the American Civil Liberties Union in the Racial Justice Program. I'm very happy to be joining you again. It's really great to be talking with this community of advocates. I remember the last time I spoke, the questions that you had were so insightful and sort of generated new thinking for advocates too on how to engage in what I think Jason described at the top as a real war over the right to vote, over the fundamental right to participate in our democratic system. I would like to talk to you, I guess, about one front on that broader battle that is interesting and important because it combines a number of the core civil rights considerations that are animating much of the work that we do. John has kind of described many of the issues that face advocates in protecting the right to vote against encroachment, issues around classic voter suppression efforts, redistricting, minority vote dilution, voter purges. These are many of the traditional challenges to the right to vote that we've seen across the country cropping up, certainly in the wake of the Supreme Court's decision in Shelby County, South Alabama. I want to talk to you a bit instead about the case that the ACLU, alongside an amazing team of other advocates, brought in Florida regarding Amendment 4 and the effort to restore the voting rights of individuals with felony convictions. I work on issues not just on the right to vote, but also surrounding criminalization of poverty and the punishment of individuals for criminal justice debt that they can't afford. And those are two different but very important and overlapping areas of civil rights law. As we've seen in recent decades, particularly in the wake of the financial crisis, states and localities have tended to heap the majority of the costs of maintaining a criminal justice system on the poorest and most vulnerable people in that system, the criminal defendants themselves, the vast majority of whom are indigent and come from backgrounds where they struggle already with poverty and then are assessed sort of crippling amounts of debt, for instance, for retaining for being assigned a public defender, as one example, even though, of course, the public defender was assigned because that individual didn't have enough money to pay for counsel. Most states in the country actually charge those defendants for those costs. And outside of the area of voting rights generally, there's a tremendous amount of consequences that this criminal justice debt can impose on people when they're seeking to re-enter society after the completion of the terms of their sentence. It has, across states, there are regimes where people are imprisoned for a failure to pay their criminal justice debt. This is flatly unconstitutional. The Supreme Court has said that that's forbidden, and yet it happens all across the country, in the South, in the North, in the West, and the East. It's part of the motivation for these court systems to tax and seek revenue from the poorest members of the community. And the issue of felon disenfranchisement is one that in some way combines many of the issues that we've discussed. As John has noted, and certainly as Gilda, our other panelists know, issues around the right to vote have always been fundamentally intertwined with race and socioeconomic status. That's nothing new at all. That's deeply a part of this. But the lens of the criminal justice system being used as a tool of disenfranchisement and marginalization is a specific one, and it's a particularly tough nut for advocates to crack. As many of you may know, the Supreme Court in the 70s decided a case, Richardson v. Ramirez, which essentially read the 14th Amendment to incorporate affirmative sanction for disenfranchising individuals due to a felony conviction. I've read Richardson v. Ramirez a number of times, particularly in relation to this case. It's actually not as bad as a lot of people think it is. It sort of just says we don't assume that it's unconstitutional to disenfranchise someone for a felony conviction, but we won't immediately apply kind of the strictest level of scrutiny to that. Regardless of whether it was limited or broad, advocates in the wake of that decision have had a really difficult time tackling the issue of felon disenfranchisement, even when there's histories of systematic racism, even when there's histories of using this as a targeted way to disenfranchise certain members of the community. The courts have, in a broad range of ways, sort of stepped back and said, this is up to the legislator, the political process to determine. That's very dangerous because, of course, a political process might not want to expand the franchise to people who might, in fact, have a different view of how the criminal justice system should work and whether or not it should be putting the costs of that system on the backs of the poorest members of the community. So advocates have had a tough time tackling felon disenfranchisement systems in the courts. And that's one reason why the community of advocates have tried to combine litigation with advocacy. And that is one of the major successes in the state of Florida. Before I was involved sort of at all in this, there was a years-long campaign from advocates across the board, from across the country, from a number of organizations focusing on Florida's permanent felon disenfranchisement statute. It was one of only 4 states that permanently disenfranchised individuals for a felony conviction with no possibility of restoration of those rights. And after a really years-long effort from an extraordinary work that was not done in the courts, that was done by changing the hearts and minds of people in the state of Florida, in this past election in 2018, sorry, I should say a year ago, his last election was a Tuesday, but in 2018, the voters of Florida approved a ballot amendment that said, essentially, individuals, when they complete their sentences, when they're done with the time, they'll be welcomed back into the community of voters, and that the permanent disqualification will terminate at that time. And the media reports at the time said that that would affect 1.4 million potential voters in the state of Florida. That's estimated to be one of the largest expansions of the franchise since the franchise was extended to women. It's an extraordinary moment where voters themselves decided to end this practice of barring people, members of the community, from the franchise. But as you know, Florida is a state where elections are decided by 500 votes, by 20,000 votes, by 30,000 votes. Indeed, the last elections in the last cycle were decided by margins as thin as those. And when you have a potential expansion of the franchise, that shakes up the political establishment. That scares people in ways that I actually think it shouldn't. I don't actually think that there is necessarily a political valence to this expansion. There's no evidence that necessarily there would be a partisan effect to enfranchising individuals with felony convictions. But the legislature and the governor passed a law in the spring I should back up and say that after Amendment 4 was passed, by 66% of the voters of Florida, which is more than voted for any other candidate on the ballot in that election, more of the voters voted for this amendment than any other issue at stake in that election. Individuals with felony convictions across the state, hundreds of individuals, registered immediately the blessing of local supervisors of elections and began voting in local elections, and many of them have stated to us in our investigation it was one of the most emotional and moving moments of their lives, that they finally felt that they had a voice that had been denied to them for so long. So in the wake of this decision, though, the legislature decided to claw back what the voters had extended. And the amendments to the Florida Constitution that voters approved said that this disqualification for a felony conviction will terminate and voting rights shall be restored upon completion of all terms of the sentence, including parole or probation. And this gets back to what I was discussing in the beginning about the way that the criminal justice system imposes fines and fees on the weakest members of the society. The legislature decided to ensure that any possible financial obligation that had ever been incurred by an individual in the sentence, in their original sentence, would need to be paid off before rights would be restored. And I think in the absolute abstract, many people, many legislators would say, well, that's required. Like if the court, imposes a sentence or imposes a cost on you, then you should do that. You should pay that in order to finish your sentence. But it ignores the fact that approximately 83% of fines and fees that are imposed by the state are never collected, because the state knows that the individuals who have been that expense has been imposed upon will never have the funds to repay that. And the legislature knew that that was exactly what would happen. They knew that this effort would blunt the enfranchising impact of Amendment 4 by essentially 85%. It would cut this 1.4 million individuals franchise to a tiny fraction. And that it would do so using perhaps the strictest financial obligations, the strictest definition of financial obligations that had existed in order to for people to be restored to the right to vote. So we filed suit, and we filed suit on a number of theories, a range of theories. But the core of these theories is the Supreme Court's holding that that you cannot deny individuals the fundamental right to vote based on their financial circumstances. That's flatly the Constitution. And that's exactly what this very law had done. And it was essentially saying to all the voters, to all of these returning citizens with felony convictions, you aren't qualified to vote unless you have enough money. So yes, the voters approved this new restoration process, but this is really going to be the rich man's path, the voter rights restoration. One of our clients, for instance, had a minor role in a broad conspiracy. She was convicted. She's currently a paralegal. And the way that the criminal justice system works is that if you are one of the sort of 30 or 40 people convicted, you are jointly and severally liable, which means liable for all of the costs of the entire conspiracy that was charged, no matter what bit playing role you had. And in her case, that amount that she was liable for was $46 million in restitution, individually. We know that no person almost in the entire world, except for the tiniest fraction of the 1%, would ever be able to pay that amount of fines or fees in order to restore their right to vote. And that was absolutely required by this new law. And that means for this person that that would be a lifetime disenfranchisement. But even the smaller amounts of money that other individuals who simply have $3,000 but have lived their whole lives as indigents and have finally kind of escaped from cycles often of drug addiction that led to these convictions, they'll never be able to pay those fines or fees either. And that is a fundamental injustice under the Supreme Court's decision in Harper v. The Virginia State Board of Elections, where it struck down a poll tax of $1.50, $46 million, $3,000, hundreds of dollars that people are assessed for their public defender when they're convicted of a felony, and sometimes even when they're acquitted. Those costs are, for the exact same reasons, not valid in order to bar someone from exercising their fundamental right to vote. So the case so even though I think that that's actually a very strong and compelling framing, there have been a couple of prior challenges to felon restoration schemes, in schemes or systems where individuals seek to restore their rights to vote. And in the past, courts, a couple of courts, a state court and the Sixth Circuit, have said essentially, well, yes, there is this right to vote and an exclusion from poll taxes for general voters, but that doesn't really count if you've committed a felony. And carved out this sort of specialist section that says, this general idea that you shouldn't have to be rich in order to vote, that doesn't really count if you're not if you committed a felony conviction. So that's some of the background case law, the out of circuit, the out of non-binding case law that we were battling against in this context, and the goal was to try to convince the court in this case that that analysis is wrong, that there is no difference between a scheme like this and essentially a general poll tax. The state of Florida, for instance, actually has amended its constitution to require that all of the funding for its court clerks and general administrative court costs come from user fees. Basically, the costs that are assessed just as a transaction for being a defendant. You are a defendant in this court, you get $80 to $85 in surcharges. You get a $700 fee. That's how the Florida Constitution requires that its courts are paid that way. How can you say, how could anyone say that that's not a tax? It is. They're generating revenue to fund the court system through the fees of the users, fees imposed on the users. So that was the theory in which we went to the federal court to challenge this law. We also challenged it, and I would want to add this even though I won't go into detail on it, based on the fact that the state of Florida had no idea what it was doing. It decided to impose all of the costs on individuals with felony convictions, but it didn't even know what those costs were. It refused, the Secretary of State of the state of Florida, the local supervisor's election, would refuse to tell anyone what they actually owed because they didn't know. Indeed, if individuals had convictions from 30 years ago, which they were struggling to surmount and actually had kind of made extraordinary strides to become kind of contributing members of the community, they actually couldn't tell them what they owed from their from their fines and fees from 30 years ago because they didn't have access to those records. But they wanted the individual returning citizens to put themselves at risk of criminal liability just by registering to vote if they happened to get it wrong. Basically, all the state would say is, well, we hope you get it right when you try to register to vote. And that is a formula for voter suppression. The goal of that system is to try to make people scared, to try to say to them, you shouldn't register to vote because we don't know what's going to happen to you. We don't know if you'll end up going back into the criminal justice system just because you tried to exercise your fundamental right to vote. So that was another key theory that we raised in this case. And as I mentioned, and I'll the out-of-circuit precedent in this area, because it involves individuals with felony convictions, in some ways was negative. The couple other times that advocates had tried to raise these challenges, they'd been batted away. But in the 11th Circuit, in this Florida case, there was a unique opening because the 11th Circuit had issued a decision that actually is, I would say as an advocate, a negative decision, a decision in the line of cases that had dismissed challenges to felony disenfranchisement systems. And that decision was called Johnson v. Governor Bush, and it's a decision from 2005 where a set of petitioners had raised a challenge to the racially discriminatory history of this provision. And there's a huge amount of evidence about that racially discriminatory history. The felon disenfranchisement provision originated in the 19th centuries right in the wake of the 15th Amendment. It was part of a series of measures that the state of Florida adopted to essentially hamstring and preclude black voters from enrolling in the franchise. It was one of a number of measures that was adopted at exactly that time. And petitioners, I think, very logically brought a challenge to the system saying that it was unconstitutional as a form of race discrimination. It's a descendant of that deeply racist past. The 11th Circuit, sitting en banc, said no. They essentially said they acknowledged that much of the history had arisen in a racially discriminatory context, but essentially reached a conclusion that the potential racist motivation had been cleansed because the felon disenfranchisement provision had been readopted, I believe, in the 60s or 70s, which is an interesting view because, of course, we know there was no racism in the 60s or 70s at all. But setting that aside, they dismissed this challenge and said Florida's permanent felon disenfranchisement scheme is constitutionally valid. But the 11th Circuit wrote a footnote at the beginning of that decision because the petitioner said that he was also too poor to pay his restitution. And in that footnote, the 11th Circuit said that's a constitutional problem. You cannot have a system where an individual's access to the franchise is dependent on their ability to pay. And under the permanent disenfranchisement system, you could apply for clemency, but you had to pay restitution before you did that. And the 11th Circuit said that is potentially a significant constitutional violation. They said, we're only upholding this system because it incorporates an alternative where that requirement is waived if you can't pay it. If you say you're not able to pay this amount of money, we'll waive this restitution requirement and allow you to access the clemency process. And that was what, in large part, we wanted to hinge our argument on. In exactly the way that the 11th Circuit said you need to have some system in place for people who can't pay, the system that the governor and the state of Florida put in place was designed to ensure that if you couldn't pay, you were blocked from this avenue of restoration. And that violated what, frankly, this very conservative court had decided in the Johnson v. Governor Bush decision. And the result is that at the hearing on October 7th, and about a week later, the district court agreed with us. And in this hearing, we're very excited by the victory because it is the first, I think, instance where a court has recognized that individuals with felony conviction have a right in this space at all. And it cited that 11th Circuit decision and listed, the judge in the hearing listed the names of each one of those judges, the en banc judges that had signed this decision in 2005, and he noted these aren't like radical leftists at all. Quite the contrary, they would really be considered to be in the middle of that really very conservative circuit. And he said, I think, really clearly to the legislature, you've got a constitutional problem with this statute. And I'm going to enjoin it, just as to our 17th plaintiffs at that moment in the process of this litigation with this preliminary injunction decision. But you really should get back to the drawing board and take another look at the system because you've got a serious constitutional problem. And I'll say, in the middle of this hearing, and my colleague Jonathan Diaz is here from the Campaign Law Center, one of our amazing colleagues who brought this lawsuit against us. The judge who decided this started reading this quote and got a little bit, I think maybe even a little teary-eyed, and I'll read it for you. He said, "Freedom is never more than one generation away from extinction. We didn't pass it on to our children in the bloodstream. The only way they can inherit the freedom we have known is if we fight for it, protect it, defend it, and then hand it to them with the well-thought lessons of how they in their lifetime must do the same. And if you and I don't do this, then you and I may well spend our sunset years telling our children and our children's children what it was once like in America when people were free." And he said that was President Ronald Reagan. And we were all, we all were like, oh. And it was this it was a direct overture to the legislature to say, this shouldn't be a political issue. This should be something that you understand generally as being a core part of democracy, a core part of what's required by the Constitution. And I think he wanted to give them one more time, one more chance to really alter and change some of the fundamental aspects of this law and ensure that it had the enfranchising impact that the voters felt it did. There's a lot more work to do on that case, and I want to pass this over to my colleague Gilda, but it's a really exciting moment that recognizes both the fundamental rights of some of the most vulnerable people in the voting rights community. Thank you.
Good afternoon.
Good afternoon.
Good. A little call and response. Y'all look like y'all, after eating, it's always a task to speak to people after lunch. So if you can, so I'm the daughter and granddaughter of Baptist preachers, so I do expect a little call and response during this event. Thanks to the ABA. Thanks, Jason, and my co-panelists for having me here. I'm honored to be here. A little bit of my background. I am a former deputy chief in the Department of Justice Civil Rights Division voting section under President Clinton and President Bush. I know I don't look that old, but that is the case. I've been doing voting rights for more than 2 decades. I am presently a tenured law professor at the University of Baltimore School of Law. I also serve as the director of litigation at the Advancement Project here in DC, which is a national office, a national civil rights office. One of my colleagues, Sherry Ann, is here, who's our Skadden Fellow, who's working with us at Advancement Project in our voting rights project. I think the title of today's panel is appropriately named, State of Voting Rights. I'm not going to bury the lead. I believe that the fight for voting rights is certainly going to be on the state level, certainly in the future. I'm going to talk to you today about voter suppression, as well as hopefully some solutions and how we can address that in the new year. I also have this is my commercial, have a book coming out in January 2020 with NYU Press, Uncounted, The Crisis of Voter Suppression in the United States. Right, so I have these for you after the talk. And so I've certainly focused a lot of my attention on voter suppression and certainly voting rights as we currently enjoy that right today. One of the things I've done recently as director of litigation at the Advancement Project is we had shadow hearings along with Congresswoman Purges' Appropriations Committee. Actually went to various states and held hearings on the right to vote to hear about post-Shelby election experiences. We actually conducted, along with 8 other, Advancement Project along with 8 other organizations, conducted people's hearings and had persons on the ground in those communities to talk about their rights to vote. One person who spoke was Annie Ruth Passmore, and she spoke at our hearing in Miami, Florida. She said, "I'm an elderly, semi-disabled citizen of Miami Gardens, Florida, a native of Columbus, Georgia. I remember the era when suppression was visible in many areas of life itself. I recall the marches, the violence, the cotton fields, the maids. I remember the black and white bathrooms and fountains. However, this last voting term in 2018, I was taken back to what's been embedded in the black culture: long lines, no assistance for elderly, and even handicapped. I witnessed several people being turned away for several reasons. No matter how hard I tried to remember the song and believe in it, it would quickly escape me. And that is, we shall overcome someday." I want Ms. Passmore to remember the words to the song more readily in 2020 than she did in 2018. And I think, and she's saying that the voter suppression that she witnessed in 2018 was reminiscent of things that she'd seen in her past, and by no means wanted to repeat that history. But I think when we look at, I think we have to look at the history of voter suppression in the United States, because as I'm sure the other panelists have said, this didn't just start in 2016 or 2018 or even in 2000. The voter suppression is certainly America's modus operandi. Right? We know that from the beginning we've had this paradoxical democracy, right? Where on the one hand, the founding fathers said that all men are created equal, and yet it only gave the right to vote to white male property owners. Indeed, you didn't even have to be a citizen to vote at the time, but as long as you were white and male and on property, you could have the right to vote. So while the founding fathers said, we hold these truths to be self-evident, that all men are created equal, in the same breath they say that certainly that enslaved persons are considered 3/5 of a person. And in creating this level of second-class citizenship, counting black and brown votes as less than those of white votes. And we move to the Civil War amendments, where we have the 13th, 14th, and 15th amendments, and we end slavery, provide equal protection, give the right to vote to black men, and we have Reconstruction, where you get a glimpse of what democracy could really look like, right? On the state, local, and even the federal levels, you see blacks being elected to state legislatures and local legislatures, and even in Congress, to levels that we have yet to see, right? So and while we're watching this happen, we also see a groundswell of opposition to this recent enfranchisement, right? It was only certainly less than 12 years, or around 12 years, of this glimpse of what America could really be. And remember, at this point, women still don't have the right to vote, right? And this is only black men and white men, and certainly Native Americans, indigenous people are not even considered citizens, and they're not given the right to vote, even with the passage of the 13th, 14th, and 15th Amendment. So our country is still operating in this paradox, but you see elections occurring, and people of color being elected, and you're seeing a representative democracy for a very short period of time. By 1901, you see the resurgence of, you see what slavery would become, essentially, with state legislatures in the South, particularly holding these constitutional conventions and passing laws like the poll tax, like literacy tests, and and felon disenfranchisement at that time. Indeed, South Carolina Senator Pitchfork Ben Tillman, I just love that name. Pitchfork Ben Tillman in 1900 said, "We have done our level best. We have scratched our heads to find out how we could eliminate the last one of them. We stuffed ballot boxes, we shot them, we are not ashamed of it." Right? And created laws that would disenfranchise African Americans for almost 100 years. It was 100 years of terrorism in the United States that dared African Americans to register and vote. In my book, I used my 99-year-old grandmother as a framework. She was born in 1919, the year that women gained the right to vote. Yet she could not vote until the 1940s. And I'm from Louisiana, she was in Louisiana, and she could not vote until the 1940s. Well, she could not vote until the 1960s, excuse me. She could not vote until the 1960s, when she was almost 40 years old. Right? She was more than 40 years old. And she could not vote, not because she was a woman, right? Had a constitutional amendment for women, had a constitutional amendment for all people, for black men in particular, to vote. Yet, living in the South, in that time, you were pro economic terrorism, threats, poll taxes, literacy tests. When I asked my grandmother, why didn't you vote until, she remembers voting for Kennedy. I said, why didn't you vote until 1960? She said black people didn't vote. And why didn't black people vote? Because of the terror that was occurring and the laws that were in place that effectively disenfranchised persons of African American descent. And these laws affected Latinx people in the Southwest, right, and certainly Native American people. And so people of color were certainly impacted by these literacy tests, poll taxes, grandfather clauses, vouchers, having persons to vouch for you in order to vote were occurring. And that did not change until 1965 with the passage of the Voting Rights Act, which has been heralded as one of the most effective pieces of legislation ever passed. It certainly closed the registration gaps. For example, in Alabama in 1965, only 19.3% of blacks were registered to vote. That's compared to 69% of whites. That's a 49% gap in 1965. In Virginia, it was blacks were registered at 38.3%, and whites were at 61%. So you had a 22% gap. In around 20 years after the passage of the Voting Rights Act, that gap was closing. In some states, in states like Louisiana, blacks had surpassed whites in regards to their rate of registration by 1988, right? And we've certainly seen those registration rates. The Voting Rights Act not only helped to affect voter registration, but also the ability to participate in the electoral process and changing from single-member districts to multi-member districts and affecting redistricting, as well as access to the voting booth in allowing voters to have the sister of their choice under Section 208. And we've seen certainly additions to the Voting Rights Act of 1965 with Section 203 and language access. So, and yet, although we've had this progress, because we've seen how voter suppression essentially works in cycles. You have times of great progress, and then you have regress, right? You have 13th, 14th, and 15th Amendments, and then you have Jim Crow laws and almost a century of disenfranchisement. You have 1965 and registration rates, and you see more black elected officials. You see blacks being elected at higher levels, and you can get to the election of Barack Obama, and then you start seeing more voters, more suppressive laws, and you see these efforts to end access to the ballot, and we continue to have and expose our democracy to these threats, right? When we're talking about threats to democracy, we're hearing a lot about Russian interference and foreign interference, but we're losing focus on what kinds of things we need to do to stop this domestic interference that's occurring on very high levels with the passage of restrictive laws. People always talk about voter ID and voter ID being like restrictive voter ID laws being like a poll tax. Certainly there are a number of threats that are internal to our ability to access the franchise. We saw that Native Americans in North Dakota and the photo ID law that required residents to show a current street address. Well, guess what? Many Native Americans in North Dakota live on reservations and don't have street addresses. Therefore, they are disenfranchised, right? They don't have the ID, does not exist, and knowing that the law would not recognize post office boxes. We've heard about Georgia and the exact match during the last election with Secretary of State and now Governor Brian Kemp. In that instance, actually impacted more than 53,000 people. We've also seen the news that now that Georgia's anticipating purging 300,000 people. Really? Really? I mean, we know about North Carolina and their pattern of their stark pattern of discrimination, as well as proof of citizenship laws, et cetera, et cetera. So we continue to see the passage of these laws that lead to the disenfranchisement of people of color, and continue to see this level of suppression. You talked about felon disenfranchisement and how it impacts people of color. The felon disenfranchisement, for example, in Florida, where it's essentially 1 in 4 African Americans were disenfranchised. I see that as very similar to 3/5 of a person. Fractions, right? Where you are systematically denying a percentage of persons the ability to register and vote. Proof of citizenship laws were certainly tried in Kansas, and that was, the court found that was that after Kansas Secretary of State Chris Kobach alleged, of course, that there were hundreds of people who were non-citizens and voting, and actually it turned out that there was 0.002%, 0.002%, yet wanted to implement a law that would disenfranchise thousands of people. So what do we do? It is, I think one of the things that I always say to people is that if we took voter ID and put it to the side, and then took proof of citizenship laws and put it to the side, and felon disenfranchisement, and say, oh, well, that only affects 100 people, 100,000 people in this state, and 100,000 people in this state. I think when you put all of these measures together, you can see the impact that it has on the ability to vote and the right to vote. So I think that we do ourselves a disservice when we silo these issues, right? We need to look at these issues as a whole and look at them as a systematic approach to disenfranchising, particularly people of color. And we know that certainly there's an impact with voter ID. There's certainly an impact on students, right, on young people, on elderly people, on women. But when you're looking at proof of citizenship and these other issues, we're talking about people of color. So what are some of the solutions? Some of the things we certainly I always give. There are 3 things I tell people to do. It's to educate. Can you say educate?
Educate.
Litigate.
Litigate.
And legislate.
Legislate.
Okay, educate.
Educate.
Litigate.
Litigate.
And legislate.
Legislate.
All right, so we have to educate our communities, educate our families on what these disenfranchising what disenfranchising devices exist in our communities and how we can overcome them. Right, so we can allow Ms. Passmore to understand and remember the lyrics to the "We Shall Overcome." Right, so we have to be able to educate. So we have to become educated on what are the voting laws in our state, right, and what is required in order to register and what is required in order to vote. We've seen voter purges, a resurgence of voter purges. And so we've been talking to people on the ground. People receive this card that's smaller than this, and they just throw it away. They're like, I've always lived here. Why do I need to return this card? Don't return the card. Get your name. They remove your name from the voting rolls, right? So we need to educate people about how we are being disenfranchised. So certainly educate, litigate. We've already talked about cases such as the case in Florida on Amendment 4. There are certainly cases under using federal statutes, using the Voting Rights Act as it still exists. I'm sure you talked about Shelby and post-Shelby, right? And so we're litigating with one arm behind our back, but still using certainly Section 2 as a tool, as well as we use Section 4E and other sections of the Voting Rights Act. One thing, and also when I was at the Department of Justice, we brought this case, Berks County versus U.S. versus Berks County, where we use Section 4E in order to enfranchise persons of Puerto Rican descent. right? So there are certainly parts of the Voting Rights Act that is still viable and still can be useful. Legislate, we talked a lot about how we've been able to use legislation. Advanced Projects involved with has been working with Vote in New Orleans and the state of Louisiana. We brought a case in we brought a case in the state court on their felon disenfranchisement law. And we were able to work with them, and certainly Vote did the work to pass legislation that enfranchised, that changed the laws in Louisiana to allow more people to register and vote. And now what we're finding is with the implementation, just as you are in Florida, is that we have the laws on the books, but now implementation is the issue, right? People aren't being able to register, and people are not able to actually cast ballots, right? So I think I'll stop there. But remember, educate.
Educate.
Legislative.
Thank you.
Well, thank you to our panelists. That was fantastic. So a couple questions, then we'll open it up to the audience and Twitter for some questions. 2020 is now less than a year away. So we have a general election coming out. If there is one state that you had to pick that you think might be a hot spot, I think I might know the answer, but many of them. But if there was one state that you sort of have your eye on moving forward over the next few months, what is it and why?
So I have to give you a story first. When I was with the Department of Justice, I was in the Department of Justice as a deputy in 2000. I was in the room when it happened, and all the Hamilton fans. When we were sitting in a room in 2000, and we had dispersed hundreds of people across the country to observe elections, and we did not have one person in Florida. Not one person in Florida. So if you're saying where would we be? Florida's certainly one place. Georgia. Because I think there's a ground game. Stacey Abrams is putting a ground game together where people are actually being registered, and if they don't get the access to vote, it'll be a lot of fun, because we'll have a lot of work to do. We're going to do the work ahead of time so that hopefully we can ensure that people can access the right to vote on election day.
Florida, Georgia.
So for me, I have my eye on Florida because I have to, but I think everyone should. So I've already explained the stakes at issue in our case, where it's really 1.4 million. It's just a huge number of people, and that really matters. But it's important to understand that's only a fraction, as we've been saying, of the many voter suppression tools that are at issue. Not only was the decision made to restrict the scope of Amendment 4 by cutting out this 83% of people who would potentially be covered, but there were new restrictions placed on students and their ability to cast ballots and that are being separately challenged. I can't say I'm a total expert on them, so I hesitate to wade into that, but they're also, given the fact that Amendment 4 was so successful, new restrictions were even implemented on the ability of voters to petition for new amendments to the state constitution, because the political system said, this could get dangerous. We could lose some of our power if we give it to the voters, who might say, yeah, we do think people should be re-enfranchised after they finish their sentences. So those are things that I know about because they're in play. I won't pretend to say that it's the only place, and I'm sorry if I'm cheating on which states matter, but that's where I will be.
Georgia and Pennsylvania. Since I started at the Lawyers Committee in 2015, I think I've filed almost 10 lawsuits in Georgia. The amount of litigation from the Lawyers Committee and other groups in Georgia just in 2018 alone was insane, from Purges to exact match to voting machines. As I said before, Georgia is going to be moving to new voting machines for the 2020 cycle. With the with the 2 Senate seats and potentially being a swing state for the presidency. There was a debacle just on Tuesday where the voting machines had problems in every single Georgia county that tried to implement them. I'm really concerned both on the voter suppression side and on the electoral integrity side for Georgia. Pennsylvania is undergoing major changes as well. They just enacted a huge reform bill. There's both, you have a Republican legislature, Democratic governor there, so you have both good and bad. New early voting reforms, very, very exciting. But also, Pennsylvania is eliminating straight ticket voting, which is a tool that has been disproportionately used by lower income and minority voters. And you know, some could say that people are counting on that having an effect on minority turnout. And Pennsylvania is also moving to new voting machines. So there's a lot of changes going on there, and will be a lot of action as election day approaches.
Thanks. So a lot of attorneys here in the audience and in their offices now that don't have civil rights or election law or voting rights practices, and they sit here and say, how can I help? Right? I don't know this area, I know it's a problem, and I want to help. What are some specific projects or training opportunities for them to get involved today? So they're not just looking, you know, next November and say, where can I go, which, you know, polling place can I watch? What can they do today to help, and then have that continue throughout the next 12 months?
Yes, I'm so glad you asked that question because there is something that every attorney and lawyer in this room can do. I want Lawyers Committee helps to run the nation's largest nonpartisan election protection hotline, and any attorney can work as a volunteer answering calls on the hotline. You don't need to have prior election or election litigation experience. We train you up. We have people like me sort of hovering, willing to help or give guidance when tough calls come up. I mean, we learn a lot of the litigation that we've done has actually arisen through phone calls that we get. I would ask that everyone write down the phone number. It is 1-866-OUR-VOTE. 1-866-OUR-VOTE. It's nationwide. It's not just for election day. And it's not just for the general election. It's for the primaries, early voting, for the primaries and early voting before the general election. We have a great roster of folks, and we're always looking to expand. So if you have any time in and around election day and are willing to make that commitment, please take my information, and we'll try to get you hooked up. Even if you don't have the time to participate in that, I definitely ask you to disseminate our number, get it out there, because as I said, that's really how we find out about problems as they're occurring. Something as simple as, hey, the polling places in Brooklyn didn't open on time. Hey, there's some problem where a bunch of poll workers are refusing to offer provisional ballots. Sometimes we just call the election officials and cure it right then. Other times, it does arise to a litigation level. So those are a couple of things you can do to make a difference in 2020.
Just briefly, and again, the Lawyers Committee is an amazing system that's set in place that is a way that I have participated in, that a lot of other folks have joined, and I think it's awesome to do that. And there's a need to modernize it so voters have ways to text problems and use whatever interface is easiest for them to identify issues in that. But that's some of our first line defense, and it's incredible to have organizations that have put so much effort into that work, because it's so critical. I guess the only thing I add to that, and this is a little bit of a well, I hope it's not a cheat, but it's referring to what my colleague Gilda was saying, which is you as attorneys in other practices, I think have an obligation to educate people in your circle. Because I think many people who aren't lawyers or who aren't part of the legal field at all, they'll see some of these suppressive measures as kind of commonsensical. Why shouldn't we have a proof of citizenship? Why shouldn't people show a passport? Like, most of us have got those, and like, yeah, then we really know that you're a citizen. And that is the way that many of these measures are sold to the public without understanding this deep effort of marginalizing, and this deep history of marginalizing people of color and poor people, and the real impact that a lot of these measures have had. And I think there's a way for you to be tools of change in your communities about explaining what's really at stake, what's going on kind of beneath the surface of those issues. And so that is a little different from the traditional mode of a litigator, but that is really a core of what's at stake in these matters.
I just want to echo election protection, and you don't have to wait until November. Primaries are coming up, and there's opportunity for working with election protection during for the primaries as well. We certainly, Advance Project, and certainly a number of organizations work with election protection on that in that area. Pro bono work can work. I need pro bono attorneys to work with me, work with Advancement Project. So certainly you can use your law degree to help Advancement Project and other organizations, but certainly Advancement Project. With your
Hey now, hey now.
Right.
Sit in the
That's
next
enough
one, Karen.
Yes.
All right, thanks everyone. Why don't we open it up to some questions? Wow, okay. We're gonna start over here, we're gonna work our way around. We have a microphone, so.
Oh, no, okay. Okay, my question has to do with voter purging and interstate cross-check, which many people, like me, believe may be responsible for who's in the White House right now. Michigan, Wisconsin, Pennsylvania haven't been affected, maybe flipped, I guess is the word, because of that Chris Kobach's misdeeds. I think, I don't know whether there's a pushback on interstate cross-check, whether it's dissolving on its own. I do believe there's a little hoping that Michigan has a Democratic Secretary of State now, things like that, but I wonder what you're doing about that problem in particular.
Anyone want to jump in first?
So yes, it's an incredibly important issue that folks have been focusing on across the board. What I can tell you is that I know my colleagues at the ACLU have won a really recent victory at the Seventh Circuit on that very issue. So Indiana had a purge provision that really facially violated really key provisions of the National Voter Registration Act. And there's a lot of folks in the advocacy community who felt that suit was pretty risky, but we won before the district court, and were won on appeal before really a pretty conservative panel of the Seventh Circuit. So I think that there are opportunities to use some of the legal systems that are in place, to use those as examples, and then sort of explain to the surrounding states what is at stake with these massive purges. But I'll say one of the things, just briefly on this, is the critical importance of monitoring, because purges are so secretive. Like it's really hard to track often what's happening, and I think my colleagues have noted how many people are being purged in Georgia for who knows all of the reasons why. It's not just interstate cross-check, it's a ton of other reasons that could be in flat violation of federal law, and it's really tricky to kind of get to the bottom of those. And I think our first step in that is monitoring, trying to determine where the big purges are happening. And again, it's really tricky not to have Section 5 as a tool to help us on this anymore, but that's what I'd say as my sort of immediate. I don't know if other folks have.
I should say inaccuracies is certainly an issue, and certainly cross-check has been found to be rather highly inaccurate, right? And there's some pushback. There's pushback from the states in using cross-check and certainly using other areas. So when we're looking at voter purges, the secretiveness is certainly an issue that we're having to combat. But also on the federal level, when you have a Department of Justice that sends letters to Secretary of States and says you need to purge your voting rolls, then that is an issue that we need to, that we're constantly paying attention to, and working with Secretary of States and registrars to learn, right? Because now since we don't have Section 5, we don't get notice of these voting changes. So we only learn about these kinds of things secondhand, right? And then when they're highly inaccurate, then it just exacerbates the problem.
And I don't know if Gilda, this is what you're referring to, but in DOJ recently went after Kentucky for not aggressively purging voters. So it's a good point. And besides the Indiana decision, which I think is huge, Mr. Kobach's leaving the Secretary of State's position, I think those factors together, you're seeing a movement of states away from cross-check towards ERIC, which is a different system that tries to do some of the same things while also promoting voter registration for folks who have moved at the same time, and is viewed somewhat more positively by the voting rights community.
Questions? Got a couple on this. Thank you.
How's the demand side going? Even as you civil rights lawyers are winning on the supply side of supplying voting rights. I'm Hank Wallace, and you're mentioning, Gilda, Miss Passmore talking about the 1960s, We Shall Overcome. That song, as sung by Pete Seeger in a Carnegie Hall concert that is available on many albums, in that same concert, he sings a song specifically about voting rights, and it is highly aspirational. And I wonder, over this half century, what trends do you all see on the demand side, on how much people are discouraged or determined to vote? Because one of those Seeger songs is, if you miss me at the back of the bus and you don't find me nowhere, come on over to the courthouse, I'll be voting right there.
I feel like I should break out in Nina Simone's Mississippi Goddamn. My goodness. All right. So it made me think of what's the soundtrack for this election? I'll have to think about it. But I think that's there's certainly we do see on the ground folk are aware that there are these impediments in place. But we also see discouragement in figuring out how to overcome them. And I think we also, because one of the areas where we don't have, where we're certainly working to improve turnout and voter participation is for millennials, right? Because they, for whatever reason, there's one right there, a few in the room. Explaining to them why it's important to vote, because I think when you hear rigged elections, foreign interference, collusion, whatever, all these things you're hearing, and they're constantly hearing these narratives. And so one of the things that we're certainly trying to do is to change the narrative, right? And so because people are discouraged, but they're also encouraged. We're certainly seeing, turnout. Of course, certainly we saw it in the midterms, right? We saw high turnout in the midterm election, but we're still abysmal, right? I mean, we still have less than 50% of the people making the determination as to is your senator or congressperson or.
Yeah, the idea that we did great.
Right, it's not, right, and then when we get to state and local elections, it's even worse. You're talking about 30 and 40%. Some contests, you're talking about maybe 15% of people in the jurisdiction get to determine who's going to be on the school board or who the sheriff is, right? So I think we just have a turnout problem, and I think it's going to take many ways to address it. But maybe if I come up with a soundtrack, it would encourage people to get out and vote.
Yeah, the only, and just so I understand, you mean improving and broadening the scope of access? Is that generally, or?
That's your job, access. I rather mean, what is the response? How determined or discouraged do you find voters? Do you see trends of people being more or less determined or discouraged about exercising the vote if the voting right is there, thanks to you?
I think that is this critical part of this discourse, and like that's what played out in Florida, for instance. Like there were literally, thousands of people who were brought to tears by the idea that they could, in the first time in their life, after being said, essentially, you're a permanent exile from our community because at some point you were convicted of a small amount of possession of a drug, for instance. You're permanently exiled from the political sphere. There's this moment where people say, I have a chance to guide my own fate and be a part of this community that I've been working to be a part of. And that's meant an incredible amount. I just seen that in speaking to people. But when you face that impediment, as soon as they get that, it's pulled right back. That hurts people. It hurts our democracy. It hurts their ability, their desire to continue to be part of the system. But there's no way, there's so much at stake that there's no way that that's not going to continue to be a battle. And I think we have to be as strong proponents for that, for their rights as possible. I don't know if that's enough of an answer, but.
Well, and what Gilda said about educating, right? I mean, we've all talked to people who've said, well, my vote doesn't matter. Why bother? People are frequently like, I grew up in New York. New York's not a swing state, but there are so many elections that matter at the local level. Your day-to-day is affected more by whether it's your police chief, your county officials, your school board, than by the policies of the president. But people don't think about that when they go to vote. Another thing, and I know both my colleagues have experienced this, part of what's really great about the work that we do is we see some of that when we talk to affected voters, but we also get to meet some really amazing people like Ms. Passmore, who are truly inspirational, and in our messaging we try to bring them out. When we did our George Mason lawsuit, we had an article go up in the Washington Post, and a George Mason student who was affected found out the reporter's information, called the reporter, got in touch with me, and then after we spoke, she started going out to other students. She found affected plaintiffs and voters, and got them in touch with us, got them excited about voting, and it was amazing. She's an 18-year-old freshman, from North Carolina. She had a lot going on, but she decided to take a ton of time out of her schedule to help other students vote in an off-year election. So I think there is a lot of energy, and it's just a matter of harnessing it and not falling for this blame the victim mentality, where we start blaming voters who aren't able to overcome the hurdles that voter suppressors are throwing their way.
And it's a long game, and I don't think we're accustomed to playing the long game, right? And so because now people are talking about, it's a year away, right? No, there's an election. There's a primary here. There's state and local elections. So I think we have to kind of change the way we think about voting and persuading folk reminding people how important it is.
So I think we have time for one more question, two more questions.
She's got the power of the microphone.
Thank you. Jason, before when you talked about what state is most important, what I thought of is the state of incarceration. And there are a number of different ways to deal with it. Certainly we want to get to no loss of voting, but either restoration after sentence or parole are two other alternatives. If we in the section or otherwise wanted to push for something, education, legislation, short of litigation, which way should we go? Should we start with the no loss, or should there be other things, depending on the state, that we should consider?
So that's a really good and critical question. You mean no loss of
Maine had no loss.
Exactly.
Yeah.
So there is no reason, I think, there is no argument, and it's interesting to argue this politically, why individuals should lose their right to vote at all upon conviction of a felony. Actually, in the decision that our judge in Florida wrote, he quoted a number of parts of the Declaration of Independence and said the right to be comes from being governed, and if you committed a felony, you're still governed, and therefore you have an intrinsic right to participate in the democracy. And he said, well, you know, those documents are aspirational. You know, I can't reach a holding based on that, but you could question whether or not this is fundamentally democratic. And I absolutely think there should be no question that the ABA's position on this should be that people shouldn't lose their right to participate in the political process due to a felony conviction. That, I think, should be full stop the position. And I don't know that I honestly have almost never heard a good argument of why that isn't true. Like, and you know, there's sort of abstract arguments about violating the social contract, but if you finish your sentence, and even in Maine, like, you can vote, they've never had this, and it's not as if that's somehow encouraged like law breaking in the state of Maine. There's no argument against it that I've ever heard, except for the reality, which is a goal of controlling the electorate. So I think that that can and should be a kind of overall position for people in this field broadly about there doesn't need to be a lot of kind of hand-wringing over, because I think the stakes are so clear. The only thing I'd add to that is, like, you mentioned the state of incarceration broadly, and that's the thing I want to focus on. My work focuses hugely on voting, but voting is only one fraction of the issues facing the poor and marginalized and excluded. And if you talk to our plaintiffs, it's a huge array of issues. Once you're returning from a felony conviction, you can't get a job. You can't get housing. No one will give you housing. And if you want to perpetuate cycles of exclusion, poverty, and crime, that's the way you do it, is by pushing people out of the political system rather than having a stake in their involvement. And I want us to remember, even as we look at the state of voting rights broadly, the way that all of these issues cross beyond just the single issue of voting to the many issues that violate the kind of fundamental civil rights and right to political participation. I don't know if that's much of an answer. I feel like saying that every state should follow Maine's model is good enough for me for an advocacy position.
That's right.
Go ahead.
Well, you're thinking about fundamental rights, right? And I think we need to hold the right to vote in the same manner that we hold other fundamental rights. I think in the book I quote a voter from Ohio who said, if I don't buy a gun, I don't lose my right to own a gun. How is it if I don't vote, I lose my right to vote? Right? And so we need to think about it. And one of the things we're advocating for at Advancement Project is the right to vote amendment. Right? And there is no right to vote. They told the Bush before that you don't have the right to vote in the United States Constitution. There are more amendments that impact the right to vote than any other right. But to have a right to vote explicitly stated in the Constitution, we think would certainly help bar some of the infringements and impediments that are currently occurring across the country.
Yeah, and to piggyback on that, not just people who've been convicted of felonies, but what about people who are in jail who haven't even been convicted of any crime whatsoever? Why have they effectively lost their right to vote? I think your question is a great one because it's something, frankly, that's getting talked about even in jurisdictions that are, for example, totally controlled by, for example, the Democratic Party. New York passed many election reforms this year, and they were great, and they deserve to be lauded for that. One reform they didn't pass was voting rights for parolees. And in Washington state as well, which is Democratic controlled, there was a lot of debate within that caucus about how far should they go in enacting those reforms, and that's I thought your answer in particular was great, speaking to that. I also think we can't be naive and think that the approach in New York and Washington is going to be the same approach that needs to be taken in a place like Kentucky, for example, where restoration of the right to vote has vacillated wildly depending on who sits in the governor's mansion, and you have a Republican legislature. In circumstances like that, a more incremental approach might be necessary.
Can I add one last thing? You don't have to go to Maine. You can go to Tacoma Park, Maryland, where 17-year-olds can vote, non-citizens can vote in city elections, and persons who were previously convicted of felony. So ways of enlarging the right to vote and focusing on residency as opposed to citizenship and enlarging the opportunity for representation, community representation.
We have time for one more question. Okay. Thank you, everyone, for coming out. Shameless pitch time. Join the ABA. After you join the ABA, join the section on civil rights and social justice. Come help provide your voice and your ideas. We're always looking for it. Also, right outside, the ABA's Government Affairs Office has a table with some iPads set up. Check out their new grassroots advocacy tools where you can contact members of Congress, and also they are piloting their new election center. So go check it out, it's right over there. And most of all, thank you to our panelists. We appreciate your time, your expertise, your insight, and thank you again. So, thank you.